Welcome to the Judicial Committee of the Privy Council, where today we are continuing the hearing in the case of Attorney General for Bermuda and Ferguson and others. The issue in the appeal is whether legislation in Bermuda, which provides that only marriages between a man and a woman will be recognised in law, infringes the Constitution. We're hearing at the moment submissions on behalf of the respondent, presented by Lord Pennick, Queen's Counsel. So I'll invite Lord Pennick now to continue his submissions.
Thank you very much, my Lord. Good morning, my lords. Good morning, my ladies. Can I turn to the question of law, whether Section 8 prohibits a law which has a religious purpose? And the starting point here is that in the local courts, the Attorney General did not dispute the religious purpose principle. The board will see that in the Court of Appeal judgment at page 425. It's paragraph 7 of the judgment, right at the end of page 425, 4 lines from the end. In Bermuda, Parliament's freedom to legislate is constrained to the extent that it must not pass legislation that is inconsistent with the fundamental rights and freedoms of the Constitution, nor, because it has a secular constitution, can it pass laws wholly or mainly for a religious purpose. This is common ground and beyond dispute. And then at paragraph 8, there's a reference to what the Chief Justice Caverley, said at paragraph 62, and there's then some 6 lines down, the authorities supported a principle agreed by all parties, namely that Parliament may not validly promulgate laws motivated by a religious purpose. Now, we say that it is well established that the constitutionality of a legislative provision depends on its purpose as well as its effects. And we rely for that principle, first of all, on what was said in Reyes by Lord Bingham at page 4967, paragraph 26, the paragraph that the board has seen now on several occasions. And on that page 4967 at letter D, there's a whole series of important constitutional cases cited by Lord Bingham, and one of those that he cites, his lordship cites, is Big M Drug Mart. But his lordship doesn't just cite that authority, he cites a specific page on that authority. The board sees that Lord Bingham cites specifically page 331. Now, my submission, board knew Lord Bingham well. He was a precise judge, and his reference to page 331 was no accident. And if we go to Big M Drug Mart, which begins on page 4761, and if we turn to page 331 of the report, which is on page 4797, the board will see that the whole of page 331 cited by Lord Bingham deals with this question of purpose and effect. By the, well, I was going to say by the upper hole punch, the board doesn't have that. Let us see a finding that the Lord's Day Act has a secular purpose is not possible. Its religious purpose is long established. And then this at D, the attorney concedes that the Act is characterised by this religious purpose. He contends, however, that it is not the purpose but the effects of the act which are relevant. And then there's an authority that is cited. And Mr. Justice Dixon, as he then was, says at F that his lordship cannot agree. Both purpose and effect are relevant in determining constitutionality. Either an unconstitutional purpose or an unconstitutional effect can invalidate legislation. All legislation is animated by an object the legislature intends to achieve. The object is realised through the impact, purpose and effect, respectively, in the sense of the legislation's object and its impact are clearly linked, if not indivisible. Intended and actual effects have often been looked to. Consideration of the object of legislation is vital if rights are to be fully protected. The assessment by the courts of legislative purpose focuses scrutiny upon the aims and objectives of the legislature and ensures they are consonant with the guarantees enshrined in the Charter. The declaration that certain objects lie outside the legislature's power checks government action at the first stage of unconstitutional conduct. It will provide more ready and more vigorous protection of constitutional rights by obviating the litigant's need to prove effects violative of Charter rights. It allows courts to dispose of cases where the object is clearly improper without inquiring into the legislation's actual impact. Now, I say that's very clear, and it is, with great respect to my friend Mr. Crowe, entirely inconsistent with what is there, with his submissions, and he has, I say, no answer to what Lord Bingham was approving if it wasn't that statement of principle. Justice Dixon goes on, and I accept this is not specifically what Lord Bingham was approving, but to like effect is page 334 at the top. It's bundle 4800. I agree with the respondent. The legislation's purpose is the initial test of constitutional validity. And then 2 lines down, if the legislation fails the purpose test, there's no need to consider further its effects, since this has already been demonstrated to be invalid. And at the end of that short paragraph, in short, the effects test will only be necessary to defeat legislation with a valid purpose. Effects can never be relied upon to save legislation with an invalid purpose. Now, Justice Dixon spoke for 6 of the 7 judges. Madam Justice Wilson gave a separate judgment precisely because she did not agree with the relevance of the purpose of legislation in those terms, although she accepted it had some relevance. That's at page 4826 and 4828. And it is, in my submission, of some significance that if we look at the Constitution, the Bermuda Constitution, section 15, which we haven't looked at so far, it's on page 1390 of the bundle, 1390. Section 15 is headed Enforcement of Fundamental Rights. And what it says at 15.1 is that if any person alleges that any of the foregoing provisions of this chapter, including, of course, section 8, has been, is being, or is likely to be contravened in relation to him, then there's redress. And that chimes with what was said by Justice Dixon, that a focus on the purpose of the legislation can address constitutionality at the earliest stage. My friend Mr. Crowe suggested, wasn't his main submission, but he suggested in argument that this case is somehow based on concepts of federalism. With great respect, not so. The passages that to which I've drawn attention, and particularly the passage that Lord Bingham cited with approval, are general constitutional principles. They're not addressing federalism. There's then the later judgment of the Supreme Court of Canada in Saguenay. That one can be found at bundle reference 3535. And the particular, again, it's a judgment, this time Justice Gascon, who is speaking for 8 of the 9 justices, including the Chief Justice, Beverley McLaughlin. And the board has seen this case already. Can I just remind the board, it's the case where the Supreme Court holds that it was a breach of religious freedom for a local council to hold a prayer meeting at the commencement of council meetings, even though attendance at that prior prayer meeting was not compulsory. And the relevant paragraph is on page 3576, the conclusion, 3576, and it's paragraph 81, where Justice Gascon for the court says a provision of a statute, this is 3576 at the top, a provision of a statute, of regulations or of a bylaw will be inoperative if its purpose is religious and therefore cannot be reconciled with the state's duty of neutrality. The legislation, including its preamble, its structure, its evolution, its context, the legislative debate, are all indicators that can be used to delineate the provision's purpose. And there's then a reference to the textbook, Ruth Sullivan's textbook on the construction of statutes. So that's the principle, and there's helpful guidance there as to how one goes about identifying purpose. Why was that conclusion reached? Well, because of the earlier passages, starting on page 3571, paragraph 71, where Justice Gascon acknowledges that the Charter does not expressly impose a duty of religious neutrality, but the duty results from an evolving interpretation of freedom of conscience and religion. And over the page 3572, paragraph 72, there's a reference to the evolution of Canadian society having given rise to a concept of neutrality. And there was some debate about this yesterday. Of course, Bermuda too is very much a multicultural society. It has people from a British heritage, Caribbean heritage, Portuguese heritage, and they have a variety of religious views, as well as many people having, of course, no religious views. But what is said is that this has all given rise to a concept of neutrality, according to which the state must not interfere in religion and beliefs. The state must instead remain neutral in this regard. This neutrality requires that the state neither favour nor hinder any particular belief, and the same holds true for non-belief. It requires that the state abstain from taking any position and thus avoid adhering to a particular belief. And over the page 3573 at the top, when the state adheres to a belief, it's not merely expressing an opinion, it's creating a hierarchy of beliefs, casting doubt on the value of those it does not share. And at 74, paragraph 74, by expressing no preference, the state ensures it preserves a neutral public space that's free of discrimination, in which true freedom to believe or not to believe is enjoyed by everyone equally, given that everyone is valued equally. A neutral public space does not mean the homogenization of private players in that space. Neutrality is required of institutions and the state, not individuals. A neutral public space free from coercion, pressure, judgment on the part of public authorities in matters of spirituality is intended to protect every person's freedom and dignity. Yes, my Lord Lord Sales.
I just wanted to be reminded, if it's okay, what the text of the Canadian provision actually said.
Yes, that appears, my Lord, at the beginning of the judgment. The court will find it at, which it gives me a moment. Yes, if your lordship turns, please, to 3569, and it's at paragraph 67, the relevant provision simply states everyone has the following fundamental freedoms. A, freedom of conscience and religion.
Yes, thank you very much.
And your lordship will recall there's a general provision which introduces concepts of justification. But that is the prima facie right that is enjoyed in Canada. Now, we say, yes, my Lord Lord Hodge.
Yes, does that primary right in Canada have to be seen in the context of Article 27 of their charter, which says this charter shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canadians?
Yes. My answer to that is that isn't the reasoning of Justice Gaston, or indeed the reasoning of Justice Dixon. But in any event, I say it is implicit in the Bermuda Constitution that the Constitution will be interpreted and applied by reference to the need to serve a multicultural society. Because
I think Justice Dixon, sorry to interrupt you, I think Justice Dixon does cite Article 27 as part of his reasoning, but I won't detain you on that point just now. But you say that is not central.
That is my submission, and to the extent that it is material, I say that the same must apply to Bermuda. The Constitution needs to be interpreted, as Lord Bingham said, according to the evolving standards that are appropriate in the society that the Constitution serves. And the society of Bermuda is as much multicultural as that of Canada. And it would be, in my submission, very odd indeed if the interpretation of the Bermuda Constitution were not to be informed by such a consideration.
Thank you.
That's my submission, my Lord. So I say that the approach taken in Canada is very important, and indeed the board has recognised the significance of Canadian constitutional law in the interpretation of what are commonly known as Westminster constitutions. In the Larimore case, can I take your lordships and your ladyships back to Larimore, which is at page 2153. And the relevant passage is in paragraph 11, which is at page 2159. Lord Mance, speaking for the board at page 2159 at letter C, has set out the Canadian Charter, and he sets it out. Yes, he sets it out there at letter C. At paragraph 11, Lord Mance says that Article 9 of the European Convention and Articles 1 and 2 of the Canadian Charter both contain outright conferrals of guarantees of freedom of conscience and religion, subject to necessary or justifiable limitations. Article 22 of the Bahamian Constitution operates in contrast by prohibiting any person being hindered in the enjoyment of his freedom or conscience. And if the board wants to see the content of Article 22 of the Bahamian Constitution, it appears at 2157, letter B. It is not exactly word for word the same as Section 8 of the Bermuda Constitution, but it is almost identical. And if we go back to Lord Mance at paragraph 11, page 2159, his lordship refers to being hindered. The board doubts whether this is a difference of substance or likely to have real effect in practice. The conferral or guarantee of freedom of conscience or religion constitutes a promise that such freedom will be protected and not interfered with by the state. And I rely on that sentence because it supports our argument that a purposive approach is appropriate. If the state is legislating for the purpose of implementing a religious purpose, then that, I say, is a breach of the promise that such freedoms will be protected. There's then a reference to Lord Bingham in the Denbigh High School case. The promise in Article 22 that no person shall be hindered in the enjoyment of his freedom of conscience can readily be equated with the concept of interference. Such positive duties as the state may have to confer or guarantee freedom of conscience are more visible in Article 9 of the Convention and Articles 1 and 2 of the Canadian Charter, but it seems to the board likely that similar duties would be held to arise implicitly under Article 22 of the Constitution. So there's a recognition on behalf of the board in that advice that the Canadian provisions in general terms are relevant, are significant in relation to the interpretation of their Bahamian Constitution, here the Bermuda Constitution. The other strand of authority that we commend to the board is the similar observations of Lord Justice Laws in the McFarlane case. Now, I accept, of course, my friend Mr. Crowe emphasised this, and I accept that Lord Justice Laws was not addressing the Bermuda Constitution. His remarks are, of course, not binding, but the significance of the judgment is that it is a powerful explanation of the secular principle which the Canadian Supreme Court acknowledged. And indeed, in answer to my Lord Hodge, it is a very similar explanation of the importance of a secular principle entirely divorced from any constitutional or statutory provision about multiculturalism. And the observations of Lord Justice Laws can be found at page 3361. There are different reports of this authority, and the board may have received the original version, the EWCA version, the Bailey version, but I don't think anything turns on the rival version. So can I focus on 3361? In this judgment, the board will remember the applicant had been dismissed from his post as a relationship counsellor because he refused for religious reasons to counsel same-sex couples on sexual matters. That was the context, and the complaint was by reference in part to Article 9. And if the board would go to the judgment at page 3368, picking it up at paragraph 21, the numbering is unfortunately different from the numbering in the Bailey version, but at paragraph 21, letter G on page 3368, there's a reference in the third line to the common law and Article 9 and the vigorous protection that they provide. And then by contrast, it is said they do not and should not offer any protection whatever of the substance or content of those beliefs on the ground only they're based on religious precepts. These are twin conditions of a free society. And then just under H, the general law may of course protect a particular social or moral position espoused by Christianity, not because of its religious imprimatur, but on the footing that in reason its merits commend themselves, and examples are then given. And at the bottom of the page, that the conferment of any legal protection or preference upon a particular substantive moral position on the ground only that it is espoused by the adherents of a particular faith, however long its tradition, however rich its culture, is deeply unprincipled. It imposes compulsory law not to advance the general good on objective grounds, but to give effect to the force of subjective opinion. This must be so, since in the eye of everyone save the believer, religious faith is necessarily subjective, being incommunicable by any kind of proof or evidence. It may be true that the ascertainment of the truth lies beyond the means by which laws are made in a reasonable society, so it lies only in the heart of the believer. 22, the promulgation of law for the protection of a position held purely on religious grounds cannot therefore be justified. It is irrational, it prefers the subjective over the objective, it's divisive, it's capricious, it's arbitrary. We do not live in a society where all the people share uniform religious beliefs. The precepts of any one religion, any belief system, cannot, by force of their religious origins, sound any louder in the general law than the precepts of any other. If they did, those out in the cold would be less than citizens, and our constitution would be on the way to a theocracy. And 23, so it is, the law must firmly safeguard the right to hold and express religious beliefs. Equally firmly, it must eschew any protection of such a belief's content in the name only of its religious credentials. And both those principles are necessary conditions of a free and rational regime. And that chimes, in my submission, with the reasoning of the Canadian Supreme Court. It is an expression of what the Canadian Supreme Court call, advisedly, the neutrality principle. And we respectfully adopt all of that. We have pointed out, it's at the end of paragraph 25 of our written case on page 1312. I don't ask the board to turn it up. We pointed out that this statement has been much approved in subsequent case law. It's also been approved, I mentioned, by Lady Hale in a number of lectures, for example, EB 5709. Now, my friend Mr. Crowe makes the point, he makes it in his written observations, and he made it yesterday, that legislation in the United Kingdom and elsewhere is often enacted to protect the interests of particular religious groups. And we've accepted that. Our response is that there is an important distinction, a vital distinction, between, on the one hand, legislation designed to protect a person's right to freedom of conscience and religion, and on the other hand, legislation which is designed to advance, to promote a particular religious belief. And all of the examples that my friend gives fall into the former category. There's legislation often enacted to protect people's religious rights to freedom of religion, freedom of conscience. For example, the exemption of Sikhs from wearing crash helmets. And the example that my Lord Reid drew attention to yesterday, that the advancement of religion is a charitable purpose. But that, of course, is not to advance any particular religious belief. It's a rule which respects the neutrality principle. Or at least it does nowadays. It didn't in Lord Eldon's day, of course, but there are some extraordinary cases, but it does nowadays respect the neutrality principle. And the
I thought it was of interest because it's difficult to imagine a thoroughly secular state, such as the French state, for example, validly having in place religion which grants preferential tax treatment to religious bodies.
Well, your lordship, I'm sure, is right. The French take these principles much further than I am arguing for, or that the Supreme Court of Canada has, to the best of my knowledge, recognised. I'm arguing for a neutrality principle. I'm not arguing that it is incumbent on the state not to recognise religious rights in some neutral way. And the objection in this case, and I'm coming on to the facts, is that a particular religious belief is given recognition and priority in this area of marriage. And it's quite important for me to emphasise that the revocation principles in the DPA that we are challenging are not needed to protect the interests of those who have a religious objection to same-sex marriage. There's no question, and there was much debate when the United Kingdom same-sex marriage legislation was going through Parliament. There's no question of churches having any obligation to conduct such marriages or to recognise them in their faith. And this was a point, it's an important point, that was made when the South African Constitutional Court considered the challenges to restrictions on same-sex marriages. And there's a passage in the judgment of Justice Sachs, Albie Sachs, for the Constitutional Court of South Africa, if the board would please turn to page 3370, it's the case of Minister of Home Affairs and Furi, and the relevant passage that deals with this question is at page 3431. Justice Sachs for the Constitutional Court, at paragraph 98 on page 3431, His Lordship says it's clear from the above that acknowledgement by the state of the right of same-sex couples to enjoy the same status, entitlements and responsibilities as marriage law accords to heterosexual couples is in no way inconsistent with the rights of religious organisations to continue to refuse to celebrate same-sex marriages. The constitutional claims of same-sex couples can accordingly not be negated by invoking the rights of believers to have their religious freedom respected. The two sets of interests involved do not collide. They coexist in a constitutional realm based on accommodation of diversity. And we respectfully adopt that. So our submission is that the constitutional right to freedom of conscience and freedom of religion precludes the state from acting on a particular religious view. And the reason for that is because it hinders, that's the word used in section 8, it hinders the rights of those who do not share those beliefs. The law is then not acting on a neutral basis. It is preferring the religious views of one religion or one sect. And there are two complementary principles at work here. The first is the duty of the state to remain neutral as between different religious beliefs and none. And if it doesn't, it hinders the full enjoyment of freedom of conscience and freedom of religion. It means that a person lives in a society governed to that extent by religious views to which he or she does not subscribe. And that's the Canadian position. And the second fundamental tenet, which Lord Justice Laws articulates, and he articulates it as well as the neutrality principle, is that religious belief is precisely that. It is a subjective belief. It's a faith. And therefore, a law which is founded on such a belief has no rational basis. It cannot provide a basis for the state to impose restrictions on those who do not share those beliefs. Mr. Crowe, in his oral submissions, as well as in his written submissions, poses a series of questions. It's in paragraphs 39 to 53 of his written case concerning this secular principle. And we've sought to answer those questions at paragraph 27 of our written case. I'll take it, if I may, briefly. His first question is, what kind of religious purpose? Well, I've addressed that. I say what is prohibited is state action, the purpose of which is not secular, but is to advance a particular religious belief, as opposed to giving legal protection to rights to manifest religious belief. His second question is, whose purpose? To which the answer is the legislature's purpose. And the general legal principle, I say, is very familiar to the board. It's stated by Lord Bingham for the Appellate Committee in the Quintavarley case. Perhaps we could just very briefly go to that. It's very familiar to your lordships and your ladyships. It's in volume 8 at page 4484. The Quintavarley case, and the particular passage in the judgment, the speech of Lord Bingham for the Appellate Committee is at 4492, my lords, my lady, 4492, paragraph 8, where Lord Bingham is dealing with the interpretation of legislation. And just above letter E on 4492, his lordship says the court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. So the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. And I'm submitting that the same approach is applicable here when one's seeking to identify what is the purpose of the legislation. My friend's third question is, must this religious purpose be the sole or the primary purpose? The primary purpose is what the Canadian Supreme Court look for. In Big M, if we go back to Big M, please, it starts at 4761, and the relevant passage is at 4802. It's page 336 of the judgment, page 4802 of the bundle, and it's just after the quotation at the top of the page, letter B. While the effect of such legislation, such as the Lord's Day Act, may be more secular, such a finding cannot justify a conclusion its purpose has similarly changed. In result, therefore, the Act must be characterised as always being a law, the primary purpose of which is the compulsion of sabbatical observance, and to like effect is Justice Gascon in Saguenay. If we go back to that one at bundle page 3593, and at page 3593, it's paragraph 127 at the top of the page, and there's some detail in the first 8 lines, and then even though the bylaw's preamble indicates an intention to ensure decorum and highlight the importance of the work of the council, it can be seen from the evidence as a whole that this purpose was secondary. So it's primary purpose that for the Canadians matters. Now, I make it clear, if necessary, I say that in the present case, we can show that Section 53's sole purpose was to effect a compromise with those who had a religious view on this issue, and I'll come to the facts in just a moment. My friend's fourth question is whether the test applies to the enactment as a whole or to the individual provisions. Well, I do say that the focus must be on what is being impugned, that is, the revocation provisions. And if those provisions fail the primary purpose test or a sole purpose test, they are unconstitutional. And it is nothing to the point that there may be other provisions of the particular legislation which are unimpeachable. Our objection is to that part of the DPA which revokes the right to same-sex marriage. And that was the approach of the Court of Appeal at paragraph 26 on page 434. The appellant then asks, how does the court identify the purpose? Well, I've addressed that already. It's by reference to all the material that identifies the context in which the provisions were enacted, and Quintavale addresses that, and Justice Gascon addresses that in the passage I've just cited at paragraph 127, and indeed at paragraph 81. Yes, my lord, Lord Sales.
Sorry, I was just going to call attention to a debate about identifying the purpose in the Countryside Alliance case, where I think it's at paragraph 44. that Lord Bingham refers to the way in which the divisional court in that case had identified the purpose of the legislation, because there was an issue whether the purpose was indeed to protect animals from cruelty or whether there was some sort of social purpose.
Yes.
To express disapproval of particular forms of recreation. I don't suggest you take up time on it now, but Lord Bingham in that case essentially endorsed a Wilson and First County property type approach to identifying the purpose of the legislation. But I rather understood from what Mr. Crowe said that may be common ground, that is the proper approach to identifying purpose now.
Yes. Well, there are many cases in the context of the Human Rights Act where the court does adopt a broad approach to identifying purpose, looking at Hansard, looking at all relevant material to demonstrate, to identify the context in which the Act was passed. And I rely on Quinta Vale. There's many cases in the authorities, SG, the judgment of my Lord Reid for the Supreme Court looks in identifying the purpose of social security legislation, looks at Hansard. I say that the courts, the board, in a constitutional context in particular, should not be handicapped in this respect. It should look at all relevant material in order to identify what the purpose of the legislation is. It should take a narrow approach.
I'm so sorry. I think I gave a wrong reference. I think it's paragraph 40, page 4174 in the electronic bundle. As I say, I don't suggest you take up time on it. It's just that it does provide a practical example where there was an issue,
Yes.
Quite a serious issue in the case itself as to how to identify the aim of the legislation. And so it's illustrative of the approach to be adopted.
Yes, well, the approach, I don't think there is much debate between the two of us much distinction between the two of us on this issue, and much is going to depend, of course, on the particular context of a particular case as to what identifies and highlights what was the purpose of the particular provision. Then my friend suggested that the Court of Appeal was not entitled to reverse the finding made by the Chief Justice that the primary purpose here was not religious. I say this is a question of law to which there is a right answer. It's comparable to the question of whether a judge is objectively biased or not. See the Gillis case, page 2457. Paragraphs 6 and 7 of Lord Hope's speech for the appellate committee. But in any event, I say the Chief Justice erred. He erred by accepting essentially the submission made by the Attorney General that the purpose was to effect a compromise by reason of a package of measures. We say the real question is, why was the compromise thought appropriate or necessary? And there's one further passage from Big M that is relevant to the approach. If we could go back, please, to Big M at page 4761, and the relevant passage is at page 4803, and at page 4803 in the judgment of Justice Dixon, just below letter B, his lordship says, what may appear good and true to a majoritarian religious group or to the state acting at their behest may not for religious reasons be imposed upon citizens who take a contrary view. And then there's a reference to the tyranny of the majority. And that's our case, that here what has happened is that the government has acted at the behest of the religious groups. And this is a familiar theme, of course, in anti-discrimination law. The barman who refuses to serve a black man or a gay woman because the customers would object is not himself prejudiced, but he's nonetheless discriminating on prohibited grounds. And the authority for that is Lord Nichols for the Appellate Committee in Nagarajan at page 3611. 3611, the relevant passage appears at page 3621. At 3621, and it's letter D, my lords, my lady, where Lord Nichols, speaking for the Appellate Committee, says in particular, if the reason why the alleged discriminator rejected the complainant's job application was racial, it matters not that his intention may have been benign. For instance, he may have believed that the applicant would not fit in, or that other employees might make the applicant's life a misery. If racial grounds were the reason for the less favourable treatment, direct discrimination is established. And we say that is the position here, that no doubt the minister, but we accept the minister was not personally motivated by religious views, but what he did was to act on and because of the religious views of part of the community. And that makes the relevant provisions enacted for a religious purpose. And that's what I want to turn to, if I may, the application of the test on the facts of this case. Yes, my lady.
Before you do, could I just put 2 points to you and ask your reaction? Firstly, if it were wrong that the Section 8 were concerned with purpose rather than effect, and that our concern should be with effects, will you be addressing that question? My second point is about the interpretation of Section 53. It's a separate point, but comes up before you look at the facts. That's, I think, on 1575, wasn't it? 1535, sorry.
Yes.
1535. It begins, notwithstanding anything, and then I'm going to put ... the judgment of the Supreme Court in Godwin, delivered on that date, a marriage is void. Now,
Yes.
First point is, it's not retrospective. So
No.
that marriages between Godwin and the date of the commencement of this provision remain valid.
Yes, they do.
In using that word, those words, Parliament has eschewed the words, and the decision in Godwin is reversed.
Yes.
You sometimes see in legislation. So Parliament has proceeded on the basis that there is this decision, but doesn't it also proceed on the basis that the decision is a good one, and that what the purpose of this section is simply to neutralise its effect? Because if that is the view of Parliament, obviously of the legislature, the courts would have to take account of that. I think
Yes.
you would.
Can I deal with those questions in turn? Your Ladyship's first question was whether we're going to go on to deal with Section 8 in effect. And the answer is very much yes. I'm coming on to that as my alternative argument. Your Ladyship's second question was as to the interpretation of Section 53. And if your Ladyship, please, would look at Section 54(2, it is made there express that nothing in these provisions affects pre-commencement same-sex marriages. It's expressly stated by the legislature, notwithstanding Sections 48(2) and 53, nothing in this Act affects the validity of a pre-commencement same-sex marriage. In other words, the legislature is proceeding on the basis, as is also implicit, I say, in Section 53, that Godwin remains the law of the land. And indeed, it does remain the law of the land for the purposes of 53(2). The basis on which the legislature has proceeded is that it accepts Godwin and makes enactments consequent on that. Now, that is, may I just complete this, my Lord Lascelles, and then of course I will happily take your Lordship's question. So may I just complete the answer? Yes,
of course, yes.
Yeah, thank you, my Lord. And I say this is important because when the board is assessing whether there is a hindrance under Section 8, when we come on to the question of effects, the hindrance is that which has been enjoyed and indeed has been implemented in the pre-commencement same-sex marriages is taken away. And that is highly relevant to whether these provisions constitute a hindrance to the enjoyment of the right to religion and freedom of conscience. I'm sorry, my Lord.
Thank you. Could I just say that I thank you for dealing with my question, because I was concerned to know whether that was your position. It affects the starting point.
Oh yes, very, very much. And I'm coming on, as I say, to deal in detail with the effects argument. This is one of two arguments that we advance. I'm sorry, my Lord Lascelles had a question for me.
Well, it's really to put you, I wonder whether you're trying to get a bit too much out of these provisions. I mean, I would have thought that they're readily explained by the fact that people had in fact relied upon and based life decisions on the validity of Godwin and de Roche, and that the non-reversal of what they had understood to be valid marriages contracted at the time that they did was simply a recognition of their own change of position and legitimate expectations that the state, which accepted the validity of their marriages at the time, would continue to do so. So I just wondered whether you had a reaction to that.
Well, I'm sure your Lordship is right in pragmatic terms that the legislature proceeded on the basis that it would be manifestly unfair and unreasonable in the light of all that had occurred to revoke the status that had been enjoyed by those who married as a result of Godwin. And of course, they continue to marry unless and until the board allows an appeal in this case. But nevertheless, I do submit, as I did in answer to my Lady Arden, that the consequence of adopting that approach, and indeed of the language of Section 53, is that at the very least, the legislature is not proceeding on the basis that it is overruling Godwin. It could have said, as my lady indicated, as one does sometimes see, that the decision in X v Y is revoked or is not to be taken as the law of the land. One often sees that in particular in the social security context, where Parliament frequently legislates to overrule particular decisions that have been taken by the courts. Nor does it say, as it could have done, that the decision in Godwin is overruled, is no longer to be taken as correct, except for cases in which it has been implemented by the celebration of marriages. So I do adopt that position, although I readily accept my Lord's explanation as to why this position has been adopted by the legislature.
Yes, thank you very much.
Can I move on to the question of what happened on the facts of this case? Now, the relevant evidence is addressed in some detail in the first affidavit of Mr. Hartnett Beasley, the Deputy Chairman of Out Bermuda, in particular at pages 534 to 561. And we do invite the board, not now, of course, to read that evidence. And we've summarised it in paragraph 30 of our written case. And can I very briefly, because I'm conscious of the time, very briefly highlight the main points. The starting point, as my friend has indicated, is that in 2013, the Human Rights Act of Bermuda was amended to include sexual orientation as a ground of discrimination. And a then opposition member of Parliament, Mr. Wayne Furbert, tried unsuccessfully to amend the provision to ensure that same-sex marriages remained void. And during that debate, he made very clear that the purpose of his proposed amendment was to uphold religious beliefs. And none of that has been in dispute in these proceedings. In 2016, he, Mr. Furbert, then introduced a private member's bill. And like his failed 2013 amendment, its purpose was to amend the Human Rights Act to ensure that same-sex marriages remained void. Again, he, Mr. Furbert, made very clear that his purpose was to adopt a religious definition of marriage. His opposition to gay rights was a product of his religious views. Again, that's simply never been in dispute in these proceedings. His bill passed in the House of Assembly. It was approved, but it failed in the Senate. And the rules are that you can retable, a member can retable a proposal, legislative proposal, after 12 months. And if the House passes it, the House alone passes it, it becomes law. Now, the Court of Appeal correctly stated, if we look at the Court of Appeal judgment at 436, paragraph 31, it's the last 5 lines of the page, refers to Mr. Furbert's private member's bill to remove same-sex marriage from the ambit of the Human Rights Act. That's the one that passed the House, was rejected by the Senate. Ms. Azar, speaking for the attorney in her evidence, said she could not speak to the motivation behind the Furbert bill, which she regarded as irrelevant. However, the Chief Justice was prepared to assume it was promoted, although ultimately not enacted, for a religious purpose. The evidence filed makes it difficult to see that it could have been other than for a religious purpose. There's no other evidence that's been filed disputing what was said in our evidence in this case. And indeed, the Court of Appeal went on at paragraph 34 at the end of the page to refer to Mr. Hartnett Beasley's evidence, his affidavit, which is unchallenged. This is the end of 437, unchallenged by other evidence of a religious agenda. And I won't read all that out, but the evidence was unchallenged. What then happens is that the Godwin decision is promulgated in May 2017. And Mr. Furbert, in the same month, says he's going to retable his bill once the 12-month period expires. So he's announcing he's going to bring forward again his bill, which has already passed through the House, and which, if it's passed again, becomes law. And what intervenes is a general election. And there's a change of government. His party, Mr. Furbert's party, the PLP, is elected. And as the board knows, the minister, the new Minister of Home Affairs, Mr. Walton Brown, introduces the bill, which becomes the DPA. And we invite attention to the second reading of this bill, which can be found in the materials at page 700. Page 700, second reading, Domestic Partnership Act. Well, it's the bill, I suppose, technically. And in the right-hand side of the page, we see the Honourable Walton Brown, who's the Minister. And after some introductory remarks in the first 2 paragraphs, Mr. Walton Brown rhetorically asked the question, why are we here? Mr. Speaker, if the board has that. We are here because we have a fundamental divide in our community. We have a quite legitimate argument being advanced for LGBT rights. We have at the same time, Mr. Speaker, a significant percentage of this population which is fundamentally opposed to same-sex marriage. Alongside this, we have a majority of members in this current Parliament who do not support same-sex marriage. How do we know that? Because of the Ferguson bill which passed through the House. Mr. Speaker, everyone in the House knows, the public will know, that in the absence of a clear government position and leadership on this issue, there would be a private member's bill, that's the Ferguson bill, tabled, which would have the effect of outlawing same-sex marriage without any rights being given to same-sex couples. And we know, I've referred to it already, that bill's primary, I would say sole motivation was a religious motivation. There's a bit more detail, and over the page, in the middle of the left-hand column, there's an inaudible interjection. And then in the next main paragraph, Mr. Speaker, part of the reason we are at this point today, and not at a point where some of us wish for us to be in terms of progress and human rights. In other words, Mr. Walton Brown is indicating a preference, if he were able to do so, to go a lot further than the compromise that he was presenting, is because of the inability of key segments on this issue properly, respectfully lead, help to educate and bring change on this issue. And then he refers to the evangelical sentiment both within the LGBT community and the fundamentalists, as he describes them. And over the page, he says in the third line, now we also have an evangelical segment within the fundamentalist movement, embraced in part by groups like Preserve Marriage. That's a religious group, as the evidence shows. Here is the fundamental problem with fundamentalism. It all emanates from a Christian mindset. You cannot base policy, this may come as a challenge for some, you cannot base policy, you cannot base sound policy on a particular interpretation of religion. Yes, we may be largely a Christian society, but we're not only Christians here. Our constitution says we should respect religious beliefs, even those who have no belief. It's embedded in our constitution. You cannot just articulate a view that because a religious interpretation argues something, that requires it's valid. It cannot be, Mr. Speaker, because if you say you should adopt a Christian interpretation, well, which version of Christianity would you embrace? They all have different views. And of course, I don't take exception to any of that. That's a sound constitutional principle. But if we go down the page to leaving out two paragraphs, we see the bill today, of course, is not ideal. We all know that, but it is the result of the political circumstances that we have to confront. What are those political circumstances? They are the Ferguson bill, as Mr. Walton Brown has indicated at page 700 in the passage I read. There will be, if there's no compromise, a bill which would outlaw same-sex marriage for religious reasons. So I say the uncontested evidence, it's clear beyond argument that Mr. Walton Brown, the minister, brings forward the compromise because the government considered, and no doubt it was right for political reasons, I don't challenge their political assessment, but they considered that they had no choice politically but to accommodate the wishes of the religious opponents of same-sex marriage. They had to do that because otherwise those religious opponents would push through a bill which only needed the approval of the House to become law. And but for those religious views opposed to the validity of same-sex marriage, the revocation provisions would not have been part of the bill, if there was any bill. The state, to use Mr. Justice Dixon's approach, the state was acting at the behest of those who sincerely believe that same-sex marriage should be prohibited for religious reasons. That's our case. We say it is no answer to this case that Mr. Brown, the minister, was not himself committed to a religious view of marriage. Indeed, he wanted to go a lot further, as he made clear. And I accept he was seeking a political compromise. And indeed, that's what Ms. Azar emphasises in her affidavit, paragraph 16, page 1226. But his decision to include the revocation provisions was an express and deliberate decision to accommodate the objections of those who object to same-sex marriage on religious grounds. There was no evidence at all, no argument in the lower courts that the minister was proceeding by reference to any other secular consideration other than to secure a compromise where one side of the compromise was the strongly held religious views. We say that makes these provisions adopted, enacted for a religious purpose. And it's nothing to the point, as contrary to my friend's submissions, that marriage, of course, has a secular element. The question is whether, in the circumstances of this case, the revocation provisions were enacted primarily, we say exclusively, for a religious purpose. That depends on why they were included as part of the bill. That's our submission on purpose. We say the Court of Appeal were absolutely right at the end of paragraph 42 of their judgment, page 441. It's the end of paragraph 42 on page 441. The one purpose that did relate to the revocation provision is satisfying the religious demands of the opponents of same-sex couples, i.e. a religious purpose. It seems to us, they say plain, that the underlying purpose of the revocation provisions was religious. That's our case on purpose. I need to turn to effect. And I don't know, my lord, whether that's a convenient moment before I start that submission.
Well, it rather looks as though it would be. So we'll adjourn now for 5 minutes and resume just before 10 to 12.
Thank you, my lord.
Well, we're now ready to resume. Lord Panic.
Thank you very much, my lord. Can I turn to section 8 and unconstitutional effect? There are three questions here. First, does the person concerned hold a belief protected by section 8? My friend says no. Secondly, is there a hindrance to the enjoyment of the right, for example, in relation to manifestation? My friend says no. And thirdly, a question of justification, which falls into two parts. Should the appellant be allowed to argue this? And if so, what is the correct approach? So can I deal with all three of those elements? First, my friend accepts the beliefs in this case are important, and he accepts that they are sincerely held. But his submission is that they're not protected by Section 8, subsection 1, which he says only protects what he described as personal, unilateral, and autonomous beliefs. That was his description. I say with great respect that is far too narrow a definition of the opinions, the beliefs that are protected by Section 8.1. I may have a conscientious belief, for example, that I'd be allowed to join a political party or to be a member of a trade union. Is my friend really suggesting that this is outside Section 8.1 because it's not personal, it's not unilateral, it's not autonomous? The case law of certainly of the Strasbourg Court is far wider than that. There's a summary, a helpful summary in Mr. Dingerman's, rather Sir James Dingerman's book. He'd been appointed to the bench by the time of his book's publication. The board will find it at page 5688. The protections for religious rights. Sir James, of course, argued many cases on religious rights in domestic courts and in Strasbourg, and he's the lead author of this with Mr. Cross. And 5691, we see that the following, it's a paragraph 3.19, the following beliefs have been held by the Strasbourg Court to fall within Article 9's ambit: pacifism, atheism, veganism, political ideologies such as communism, the Salvation Army, pro-life secularism and conscientious objection. Well, certainly to want to associate with a political ideology, to be a member of the Salvation Army and to take part in their activities are not personal, unilateral, or and autonomous activities. We say it would frustrate the purpose of Section 8.1. It would breach Lord Bingham's principle in Reyes about giving these rights a broad interpretation, to seek to exclude a sincerely held and important belief, religious or conscientious belief, because it concerns whether legal protection should be enjoyed for the status of same-sex marriage. And we say that is particularly so when the leading authority in the appellate committee, which is Williamson on corporal punishment, says that the equivalent of Section 8.1 is a threshold requirement. Can I take the board to Williamson? It starts at page 4729. It's the speech of Lord Nichols for the appellate committee. He's dealing, the board will recall, with the parents' belief that they should be able to use corporal punishment. The teachers should be able to use corporal punishment on their children. And at page 4741, paragraph 23, Lord Nichols is addressing this question of what are protected beliefs. And at paragraph 23 at the bottom of the page, he says a belief must satisfy some modest, objective, minimum requirements. These threshold requirements, as he describes them over the page, they must be consistent with basic standards of human dignity and integrity. He then says they must relate to matters more than merely trivial. They must be coherent. And then at E, he refers to Article 9 of the European Convention, covering the atheist, the agnostic, the skeptic, the beliefs are placed on an equal footing. He says if its manifestation is to attract protection, a non-religious belief must satisfy the modest threshold requirements implicit in this article. Now, all of that gives the flavour of what is required. This is not an exclusionary principle. It's designed to be widely embracing. We also draw attention to the speech of Lord Walker at page 4749, and just above, on 4749, just above letter D, Lord Walker, dealing with the concepts in Article 9, says plainly, these expressions cover a wider field than even the most expansive notion of religion. Pacifism, vegetarianism, total abstinence from alcohol are uncontroversial examples of beliefs which would fall within Article 9. Now, if that's right, and it is, then we say that a conscientious or religious belief in the validity of same-sex marriage is at least as entitled to protection under Section 8 as a belief in the right of corporal punishment for your children, or a belief in total abstinence from alcohol.
Lord Panic, in the passage that you cited, well, a page you cited from Sir James Ingham's book a moment ago, you referred us to paragraph 319. 320 contains a helpful list of beliefs which the court has held not to fall within the scope of Article 9. In relation to both, it would be quite useful to have the authorities which have the footnotes. We don't, unfortunately, have the footnotes.
Yeah, I did notice that, my lord, as I was going through it. We will indeed supply the board with the relevant pages where the where that is provided. Nowhere in my submission does one find a statement that Article 9 excludes that which is, only covers, I apologise, only covers that which is personal, unilateral and autonomous. If there were such an authority, I've no doubt my friend Mr. Crowe would have referred to it. In this case, the Court of Appeal identified at paragraph 57 of its judgment the 4 categories of belief. It's at page 449, which are undisputed as to their sincerity and as to their importance. I won't go through them because my friend helpfully read it out yesterday, but it's there at page 449, and none of it was in dispute. The evidence is summarised, if the board wants it, at paragraph 42 of our written case, EB, the electronic bundle 1324. The Court of Appeal's approach is at paragraph 70 of the judgment at page 456. And they say at the end of paragraph 70, belief in marriage is in our judgment a fundamental one, whether in opposite sex marriage or same-sex marriage. And we say that is manifest from this case, that people do feel in Bermuda and in many other countries very, very strongly on this subject. There are sincere opinions relating to this matter. Now, we say, applying the language of Section 8, the revocation provisions, as I indicated in answer to my lady, Lady Arden, remove the right previously enjoyed by same-sex couples to enter into a valid marriage. They remove the rights of officiants like Sylvia Hayward Harris to conduct a valid marriage, or all in accordance with religious and conscientious views. And I do say that this is a hindrance, to use the language of Section 8. Now, my friend says, well, there's no element of compulsion here. It's not one of those cases where there is a prohibition on, for example, eating kosher meat or something of that sort. But it's a hindrance nonetheless, because the state is restricting. The state is, we've lost Lord. The state is restricting the courses of action that are available to same-sex couples. And there's a helpful passage on the scope of the provision in Big M. If we could go back, please, to Big M. It's at page 4802 in the judgment of Justice Dixon. 4802 at letter H on that page. Justice Dixon 4802, his lordship says, freedom can primarily be characterized by the absence of coercion or constraint. If a person is compelled by the state or the will of another to a course of action or inaction which he would not otherwise have chosen, he's not acting of his own volition. He cannot be said to be truly free. One of the major purposes of the Charter is to protect within reason from compulsion or restraint. Coercion includes not only such blatant forms of compulsion as direct commands to act or refrain from acting on pain of sanction. Coercion includes indirect forms of control which determine or limit alternative courses of action available to others. Freedom embraces both the absence of coercion and constraint and the right to manifest beliefs and practices. It means that subject to such limitations, no one is to be forced to act in a way contrary to his beliefs or his conscience. And there are constraints here. They're very important constraints that hinder the ability of those concerned to exercise their freedom of religion and conscience, because they are unable to enter into, to celebrate, to officiate act a same-sex marriage. My lady, Lady Arden, put to my friend yesterday that there are people who have a conscientious objection to marriage and so wish to enter into a valid legal partnership. And that, of course, was the substance of the Steinfeld case. Can we just go to that? It's at page 4702. Steinfeld and the Secretary of State. This was the case concerned with whether a couple who had an objection, conscientious objection to marriage, were entitled to a civil partnership, which of course then at that time was only available under domestic law to same-sex couples. I recognise it wasn't an Article 9 case, but Lord Kerr for the Supreme Court addressed the matter at paragraph 6 in a helpful way. It's at page 4713. And at page 4713, Lord Kerr, describing the background, says the appellants are a different sex couple who wish to enter into a legally recognised relationship they have a conscientious objection to marriage. They want to have a civil partnership with one another. And this is the opposite of such a conscientious objection. The respondents in this case have a conscientious belief in the validity of marriage for same-sex couples. And paragraph 12, Lord Kerr recognised in the Court of Appeal this matter was addressed by reference to Article 8, private life. And of course, in Bermuda, there is no equivalent of Article 8. There's no right to private life in the Bermuda Constitution. We do have the Court of Appeal judgment as well in the Steinfeld case at page 4650, where it starts, and my Lady Arden, in the lead judgment for the court, explained the circumstances at 4659, paragraph 5, that the couple have a deep-rooted, genuine ideological objection to marriage based upon what they consider to be its historically patriarchal nature. They consider the status of civil partnership would reflect their values, give due recognition to the equal nature of their relationship. And similarly, Lord Briggs, then of course Lord Justice Briggs, to like effect, at page 4699, paragraph 168, his lordship referred to those who have a sincerely held view that marriage has not escaped its supposedly patriarchal origins. And my friend has to submit, consistent with his argument, that those conscientious views are simply not within the scope even of section 8. And I do say that it would be quite remarkable and a breach of Lord Bingham's principle in Reas for Article 8 not to extend to such conscientious views, sincerely held on an important matter, which on any normal use of language would be regarded as religious or conscientious opinions. There is no reason for Article 8 to be given a narrow interpretation, as my friend submits. Yes, my Lady Arden has a question.
Very quickly, you've said 3 times Article 8, and I want to be clear, you're talking about Section 8.
I do apologise. I apologise. Section 8. Yes, Section 8 mentioned Article 8 because there's no equivalent of Article 8 in Bermuda. But thank you, my lady. I apologise. I misspoke. Indeed, I say it would be quite even more remarkable for Section 8 to be given the narrow construction for which my friend contends, however sincere and important these religious and conscientious views, and even if there's no justification for the interference with them. The board may also get some assistance on this question from Lord Mance in the Larimore case that I took the board to earlier. Could we go back, please, to Larimore, page 2160, the Bahamian case? The board may find it of assistance also to look at what Lord Mance said for the board at 2160, paragraph 14. And in the 4th line, Lord Mance says freedom of conscience is in its essence a personal matter, but then he explains what he means by that. It may take the form of belief in a particular religion or sect, or it may take the form of agnosticism or atheism. It is by reference to a person's particular subjective beliefs that it must be judged whether there has been a hindrance. In other words, you ask, what are the beliefs of this particular complainant? And it is in the context of those beliefs that you ask the question, has there been a hindrance? And we know what the personal beliefs of these respondents are. They sincerely believe, and it's an important matter, they sincerely believe that there is and should be a right to the validity of same-sex marriage. Then my friend says, well, this right does not entail any obligation on the state to take positive action. That's his next submission. Again, the Canadian case law is instructive on this matter. Can I take the board, please, to the Law Society of British Columbia case, which is at page 3078. The context here is that the Supreme Court of Canada found that it was a prima facie interference with religious freedom, although it was found to be proportionate, but it was a prima facie interference with religious freedom for the Law Society to refuse accreditation to a Christian law school because it required students to abstain from, quote, sexual intimacy that violates the sacredness of marriage between a man and a woman. So there was a purity clause in the requirements of this university. And the judgment confirms that for the Law Society to withhold legal recognition can hinder freedom of religion or conscience. And we see that in the judgment of the court, which begins, there's a long headnote, but if we turn please to page 3114, we see the judgment of the majority of the court. The circumstances are set out in paragraph 1 as I've described them. Paragraph 2, a decision of the Law Society not to recognise the law school. In the last 2 lines, the argument is that the decision violates religious rights, and over the page, paragraph 3, the finding is that the decision not to recognise the law school represents a proportionate balance. So the law school wins, the law school loses on proportionality, but on the question of whether religious rights were engaged, if we could go please to page 3142, paragraph 73, the board will see, to summarise, it's clear from the evidence that evangelical Christians believe that studying in an environment defined by religious beliefs in which members must follow particular religious rules enhances the spiritual growth of members of that community. The covenant supports the practice of studying in an environment infused with evangelical beliefs. The next question is whether the decision of the Law Society not to approve the law school limits the ability of the community members to act in accordance with those beliefs and practice in a manner that's more than merely trivial or insubstantial. Was this decision capable of interfering with religious belief or practice? This is an objective analysis that looks at the impact on the claimants rather than the impact of the implicated practices or beliefs on others. And over the page, by interpreting the public interest in a way that precludes the approval of the law school, the Law Society has interfered with the ability to maintain and approve law school as a religious community defined by its own religious practices. The effect is a limitation on the right of community members to enhance their spiritual development through studying law in an environment defined by their religious beliefs. Now, on Mr. Crowe's approach, this is nothing to do with coercion. Nobody was saying, Law Society were not saying that you couldn't proceed in a university to impose these rules, to have an educational community that respects these principles. The case is not concerned with the personal, the individual, the autonomous. It is concerned in this respect with whether or not it is a breach of religious conscientious opinions for a state body, because the Law Society is treated as a public body, the state to refuse recognition to those religious and philosophical opinions. So I do say that this case is inconsistent with my friend's entire approach. Equally inconsistent with my friend's approach is Saguenay, which the board has seen. This was, the board remembers, the case about Christian prayers at the beginning of the council meeting. Again, there's no compulsion. There's no interference with anybody's autonomous, individual, personal rights, because nobody was required to attend. But nevertheless, the Supreme Court finds this is an interference with the right to freedom of conscience, freedom of religion. So again, that case is inconsistent with my friend's approach. There's a third example that we have given. It's less valuable because the board does not address the point directly, but it's an instructive example. It's the case of Sanatan Dharma Mahasabha, which is at 5188. At 5188, this is the board's decision on appeal from the Court of Appeal of Trinidad and Tobago. And the context is that the state creates an honour. My friend mentioned this case. The state creates an honour in Trinidad, the Trinity Cross of the Order of Trinity. And the local court, the High Court, found that this was a breach of freedom of conscience under the Constitution. It was a breach of the rights of members of the Hindu and Muslim communities because an award, the Trinity Cross, is associated with Christianity. The claim failed in the High Court in Trinidad only because of the savings clause in the Constitution. And but for that, the claim would have succeeded, and it would have succeeded even though no one was obliged to accept such an award. There's no coercion. It's not a case about personal, autonomous action. Muslims and Hindus weren't required to do anything. They weren't required to believe anything. But in practice, they would have been reluctant to receive such an award, and there was no justification for calling the award that. What the board did was to allow an appeal on the savings clause provision, and so the claim succeeded. I emphasise, I don't want to mislead the board, there was no analysis because there was no appeal against the finding that this fell within the scope of freedom of conscience. But it's an interesting case because the advice of the board delivered by Lord Hope contains no suggestion that it's surprising, remarkable, wrong in principle, that such a case should be dealt with within the scope of freedom of conscience. So I say it's yet a further example. Yes, my Lord, Lord Sales.
Yes, I've been puzzling about whether thinking of this in terms of positive obligation is quite the right way of thinking about it, because the state positively has a practice of giving legal endorsement, that is state endorsement, to marriages between a man and a woman. And although one could say what's being complained of here is that some positive things should be done in relation to same-sex marriages, I wondered whether actually it's sort of on the cusp between an interference and a positive obligation in Strasbourg terms, if one thinks of it in that way, because it's almost as though the state has stayed, although it has a practice of endorsing legally by giving legal sanction to a marriage between a man and a woman, it has stayed its hand in relation to marriage between same-sex couples. And I just wonder whether you had any observation about that.
Well, I'm grateful. My observation, my Lord, is that in terms of Section 8, what matters is whether it's a hindrance. That's the question. And I, for my part, wouldn't wish to seek to categorise this as negative or positive. I'm content with it being a hindrance. And I emphasise that concept because Lord Mance, in the Commodore case, addressed that question. Could I just, I hope for the final time, ask the board to go back to Larimore, and if the board looks at page 2157 in Larimore, we have, and I've taken the board to this already, we have Article 22(1) of the Bahamian Constitution, very similar to what we have here. And at page 2159, at paragraph 12, Lord Mance addresses the meaning of 22(1). He says the suggestion, paragraph 12 on 2159, the suggestion that Article 22(1) deals in its first part with inner freedoms, its second part with outward behaviour, is in the board's view a misreading. The first part defines the protection afforded. It covers both what the ECJ called the forum internum and the forum externum. The second part specifies various aspects of the freedom of conscience, the enjoyment of which is by virtue of the first part not to be, quote, hindered. By use of the word includes, it specifies them on a non-exclusive rather than an exclusive basis. So one doesn't need to show an interference with manifestation. Question is there a hindrance, which is a general question? And Lord Mance returns to this point at 2161. Well, it starts at the bottom of 2160 because the argument being advanced is that the proper term is forbade. He says at the last line of 2160, in any event, the word forbade puts the barrier too high. What is required is hindrance, which is not the same as prevention. And I say, and I respectfully adopt what Lord Sales puts to me, that in Bermuda, if you are an opposite sex couple, you can have a marriage which is valid, which is recognised, which is has all the consequences in terms of society of a valid marriage, but you can't if you are a same-sex couple. And I say, on any normal use of language, this is a hindrance. And we are very concerned, for our part, by the implications of what my friend Mr. Crowe is contending for. I mean, supposing, for example, that the state were to legislate that only a marriage conducted in a church will be recognised as valid in law. Supposing the religious groups persuade the minister that this is a jolly good idea. Only if you get married in a church can the marriage be valid in law. It's not good enough you're married in a mosque or a synagogue or in a registry office. Well, there would be a very strong case, I would submit, that the denial of a valid marriage would hinder, would be a hindrance to freedom of conscience or religion. But on my friend's approach, this would be outside the scope, completely outside the scope of Section 8, however unjustified the rule may be. So I say, with great respect, my friend's narrow approach is unsustainable. I say there is a hindrance here. I say we do not need to show any interference with manifestation for the reason I've just given, that Lord Mance in Larimore says that what follows after hindrance, in the words of the provision there, Article 22(1) of the Bahamian Constitution, here Section 8, are merely examples. My friend says, well, you've got to show interference with worship, teaching, practice, observance. Not so. Lord Mance expressly rejects those. He says that they are, it's not an exclusive test. Those are examples. They are not requirements. And any such approach to that promulgated by my friend, argued by my friend, would breach, again, Lord Bingham's principle in Reas. In any event, in the present case, if it matters, we do seek to manifest our religious and conscientious beliefs. We seek to enter into valid same-sex marriages by entering into them, celebrating them, by officiating them. And the revocation provisions are a clear hindrance and interference with those beliefs. And that was the judgment of the Court of Appeal. They dealt with it at paragraph 81 of the judgment. I'm sorry, the Chief Justice dealt with it at paragraph 81 of his judgment. It's at page 248, and at paragraph 89, which is at page 251. And we therefore, for all those reasons, do submit that my friend's submissions on effect should be rejected. None of the authorities, in my submission, none of the authorities on which my friend relies assist his argument. He relied, first of all, on the Supreme Court judgment in Lee and Asher's Baking. Could I invite the board back to that one? It's at page 3273. The context here is that Lady Hale, speaking for the court, accepted at paragraph 41 on page 3295, letter E. Her ladyship said at the end of paragraph 41 on page 3295, I see no reason to doubt that support for gay marriage is indeed a political opinion for this purpose. But the reason for that is that that was the relevant legal claim that was being advanced. See paragraph 37 on page 3293. That does not address, far less exclude, that there may, on the facts in the legal context, also be a religious or conscientious belief in the validity of same-sex marriage. It all depends on how the matter is argued and what the relevant legal provisions are. My friend also relied on a series of Strasbourg decisions. Now, many of these are admissibility decisions. Many of them of quite old vintage. In none of them was Article 9 the central issue. And therefore it's unsurprising that in none of them is there a detailed assessment of the scope of the provision. And I would also add, with all due respect to the European Court, we all know that the jurisprudence of the Strasbourg Court is heavily reliant on the factual context in which the particular claim is brought and addressed. Now, many of these European Court decisions on which my friend relies, insofar as they concern marriage at all, were made in the context of and were strongly influenced by Article 12 of the European Convention, again a provision which is not found in the Bermuda Constitution. And we see what Article 12 says in the Schalk case, which is at, well, you find it at 5217, page 5217. This was a case where a same-sex couple were complaining that in Austria there was no right to a valid marriage. And at 5217, the European Court, this is not an admissibility decision, at 5217, Article 12 is set out in paragraph 39. Men and women of marriageable age, well, let me rephrase that, men and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. That's the provision. And it's in the light of that provision that the European Court reaches the conclusion it does in Schalk, that the complaint, we have no right to same-sex marriage, failed. And we see that at, in particular, paragraph 101, which is on page 5228, where the court says, insofar as the applicants appear to contend that if not included in Article 12, and they've explained that it is not included in Article 12, the right to marry, well, for same-sex couples, the right to marry might be derived from the discrimination provision taken in conjunction with Article 8, that's family life. The court is unable to share their view. It reiterates the convention is to be read as a whole. Its articles should therefore be construed in harmony with one another. Having regard to the conclusion reached above, namely that Article 12 does not impose an obligation on contracting states to grant same-sex couples access to marriage, Article 14, taken in conjunction with Article 8, a provision of more general purpose and scope, cannot be interpreted as imposing such an obligation either. And that's the reasoning of the European Court. Article 12 is confined to a marriage between man and woman, and you can't ignore that when you look at the other provisions of the European Convention. And yes, my lord, Lords of the Sales.
Sorry, just so I can understand this reasoning. That seems to be reasoning that in the context of the convention, Article 12 is a lex specialis dealing specifically with the topic of marriage, and that, so. and that the rest of the convention falls to be examined in its application around that foundation. Is that have I understood the reasoning?
Precisely so, and the phrase lex specialis is used in other cases. And of course, that case will be much debated, I know, in the Cayman Islands case, which is pending. As your lordships, your ladyships know, the same constitution is to hear the Cayman Islands case on the 23rd and 24th of February, Day and Bush. And whatever the implications of that for the Cayman Islands, and I make no submissions, of course, in relation to that, that problem, if it is a problem, does not apply in the Bermuda context, because we have in Bermuda no equivalent of Article 12 of the European Convention on Human Rights. But that provision explains the Strasbourg jurisprudence. That's the submission I make, and it explains a number of the cases that my friend relies on. For example, the Johnston case my friend drew attention to. Johnston is at page 2926, and the relevant passage is paragraph 57 of that on page 2943. This is a case involving a husband and wife who claimed a right to divorce. And at paragraph 57 on page 2943, we're told that Article 8, with its reference to the vague notion of respect for family life, might appear to lend itself more readily to an evolutive interpretation than does Article 12. Nevertheless, the Convention must be read as a whole. The Court does not consider a right to divorce, which it has found to be excluded from Article 12, can with consistency be derived from Article 8, a provision of more general purpose and scope. Similarly, Parry, the same approach is adopted. This is the sex change operation case. I won't go to it, but it's the same point at 3854. And similarly, X and Germany, which is at 5461. Again, there's the reference to Article 12, and again in Khan and United Kingdom at 2998. So we do submit that the Strasbourg jurisprudence, certainly in relation to marriage, is to be understood by reference to Article 12 being the lex specialis. The other case from Strasbourg on which my friend relied was Pretty. And can I take the board back, please, to Pretty? It's at page 4014. And the relevant paragraph here was paragraph 82 on page 4053, concerned with Mrs. Pretty's contention that Article 9 covered her belief in the right to assisted suicide. And at 82, the court says it doesn't doubt the firmness of her views, but would observe that not all opinions or convictions constitute beliefs in the sense protected by Article 9. Her claims do not involve a form of manifestation of a religion or belief through worship, teaching, practice, or observance, to which my answer is that in the context of the Bermuda Constitution, that is not a requirement. The test is hindrance. And the Lord Mance, in the passage that I took the board to express in Larimore, expressly rejected, it's paragraph 12 on page 2519, expressly rejected the suggestion that it was necessary to prove an interference with the manifestation of worship, teaching, practice, or observance. So I don't accept, with respect, that that is a helpful guide to the scope of Section 8. Yes, my lady, Lady Arden has a question.
You were talking about the lex specialis case. Pretty is also a lex specialis case because there is the right to life, and therefore it is contra legem to have a right to death and a right to espouse views supporting the right to death.
Well, I'm grateful. I respectfully adopt what your ladyship says. Your ladyship is absolutely right. And of course, all of these cases need to be considered in their particular factual context and by reference to the specific provisions of the constitution or convention that is being interpreted. The other, and I'm speeding along because I have ground to cover, can I also make some observations on Halpern, because my friend drew attention to the Canadian case, the Ontario Court of Appeal case of Halpern, which is at page 2555. Each of the courts below found this case not helpful on for the principle for which my friend contends, and the starting point for consideration in relation to Halpern is that the context is a decision of the Court of Appeal recognising that the Charter of Rights does confer a right to a valid same-sex marriage under Article 15 of the Charter. That was equality without discrimination. And other provincial courts of appeal have reached the same conclusion, and there's now federal legislation on the subject. And the court emphasised right at the start of the judgment at 2565, paragraph 2, that the case was about the recognition and protection of human dignity and equality in the context of the social structures available to conjugal couples in Canada. It emphasised on the next page, 2566, that marriage is one of the most significant forms of personal relationship. It's been a basic element of social organisation in societies around the world. It enables individuals publicly to express their love and their commitment. Society publicly recognises these expressions of love and commitment, granting them respect and legitimacy as a couple. It reflects society's approbation of the personal hopes, desires and aspirations that underlie loving, committed conjugal relationships. This can only enhance an individual's sense of self-worth and dignity. And that chimes with the evidence in our case that I referred to yesterday afternoon. And at 6, the ability to marry is something that most Canadians take for granted. Same-sex couples do not. They are denied access to this institution. And similarly, at paragraph 108 on page 2596, they say it is in our view that the dignity of persons in same-sex relationships is violated by the exclusion of same-sex couples from the institution of marriage. And they then say it falls within the scope of section 15.1, and then they deal with justification. And I'll come back, if I may, to the very helpful analysis of justification of that court when I come to justification. That dealt with the main plaintiffs in Halpern, who were individuals who claimed a right to enter into a valid same-sex marriage. There was a subsidiary argument by a church which argued that its freedom of conscience rights were also infringed by its inability to conduct a legally valid same-sex marriage. And that issue, that claim was rejected by this court. There was, of course, no appeal on that issue to the Supreme Court of Canada because the claimants had won on other grounds. And if the board turns to page 2579, well, at the bottom of 2578, it's a cross appeal where the church takes the position that the common law definition of marriage breaches its freedom of religion under section 2A of the Charter. And then at 52, the church framed its argument this way: there is no obligation on the law to recognise religious marriage as a legal institution. However, once it decides to do so, it cannot withhold recognition to any religious marriage except in a constitutionally lawful manner. And that leads to the conclusion that my friend referred to at 53, this case does not engage religious rights and freedoms. Marriage is a legal institution. This case is solely about the legal institution of marriage. It's not about the religious validity or invalidity of various forms of marriage. We do not view this case as in any way dealing or interfering with the religious institution of marriage. Now, that is very different, in my submission, from the way we are putting our case based on the evidence that we have in our case. It's simply not the argument that we are advancing in these proceedings. So I respectfully submit that that part of Halpern does not assist my friend, and even if it did, I would respectfully submit that the arguments that we have advanced for the reasons we've advanced on section 8 are correct, and to that extent Halpern is not persuasive in relation to the Bermuda Constitution. So for all those reasons, I say whatever the board's views on purpose, this is a plain case where there is a breach of section 8, the prima facie right under section 8, subject to justification in the circumstances of this case for all the reasons I've given. That leads to the question of justification. My Lord Reid has already indicated the board wants to hear argument de bene esse. We say the circumstances here are quite extraordinary. In the Supreme Court of Bermuda, the appellant deliberately and advisedly decided that it would not adduce evidence and it would not make submissions seeking to justify any prima facie breach of section 8 or indeed section 12. And that was despite expressly being invited by Chief Justice Caverley to consider doing so. And the board sees that at page 171 of the bundle. Can I remind the board of what was said in the case management ruling by His Lordship the Chief Justice Caverley at page, well, it starts at 172, where at letter D at the bottom of page 172, His Lordship says the central issues in controversy in relation to determining whether sections 8 and 12 have been contravened, and then he sets them out: prima facie a breach, and then there's proportionality. And at E, he says over the page 173, the respondent's evidence, as are in both cases, only appears to be responsive or explicitly responsive to issue 1. That's the prima facie breach. The respondent's skeleton submissions also appear to adopt a similar course. The court has never come across a section 15 case, and I showed the board section 15, it's the right to bring a complaint, where the Crown is content to pin its colours to a single mast and rely upon the court finding that no prima facie interference with protected rights has occurred. Should this omission be unintentional, the court is willing to grant the respondent leave to file and serve. I make two comments. I, for my part, the board has its own extensive experience. I can't think of a case where a state, a public body, a government has adopted the approach that was adopted in this case, that we will confine our arguments to contending there is no prima facie breach. And it is a remarkable thing to do because, as I've indicated, the Constitution is structured on the basis that prima facie rights are to be broadly interpreted, in part because the state always has the opportunity to seek to justify a breach of a prima facie right. And the other comment I make is that the Chief Justice expressly, deliberately gave the appellant notice of this issue and expressly invited consideration of whether the state really intended so to confine its arguments. And the consequence of what the Chief Justice had said was the further affidavit, the second affirmation of Ms. Adar, and the board will find that at page 912 of the bundle. Ms. Azar of the Cabinet Office, she is the permanent secretary, she tells the board, of the Ministry of Home Affairs. She's duly authorised to swear the affidavit on behalf of the respondent. And at page 913, paragraph 4, she states her understanding that the court, that's the Chief Justice, has raised the possibility of the government having omitted in its evidence to deal with these matters. And she notes the statement of the Chief Justice. She expressly notes the statement of the Chief Justice. The court has never come across a case of this nature. 5, the respondent is advised and will argue that in this case, no question of interference with the applicant's protected rights arises. And then she adds some detail in paragraph 6, insofar as freedom of conscience is enjoyed. The enactment was not intended to interfere with such freedom. For this reason, she says, no attempt has been made to provide evidence to justify its terms insofar as these have been objected. The respondent would be adopting a false position were it to do so. And then at 7, she similarly says that's her position, that's the government's position under section 12. And at the end of paragraph 7 on page 914, for this reason, there is no requirement to justify any of its provisions. Again, the respondent would be adopting a false position were it to do so. And that remained the position of the appellant, both before the Chief Justice and before the Court of Appeal. And I do not accept, with the greatest of respect, I do not accept that in these extraordinary circumstances, where the appellant has advisedly, having been alerted by the Chief Justice to the question, has advisedly and deliberately decided that she will confine her case to an argument on prima facie rights, that it can now be open to her to seek to advance a purported justification that, as the board sees, has played no part whatsoever in her or the government's analysis of this case prior to the appeal to the board. There is no assessment whatsoever by the appellant of any balance of interests, any proportionality analysis. On the contrary, the appellant tells the board that her position, the government's position, is that it would have been a false position to conduct any such balance, given the views that they had adopted. And we say, in those extraordinary circumstances, it is far too late for the appellant now to change her position and to seek to justify. And it is particularly inappropriate when the board lacks any consideration, for those reasons, lacks any consideration by the local courts of the strength or otherwise of any justification defence. There's no analysis in the judgments of the Chief Justice, the Court of Appeal, on what are the legitimate aims on what are the strengths or otherwise of the interests there served. No analysis of the competing detriments to the complainants and those like them. The board invariably requires and respects and is assisted by the views of local courts. And indeed it goes further, because in the light of what the Chief Justice told the appellant, we for our part wrote a letter the next day, the 18th of May, which is at page 5855, paragraph 5e. I don't ask the board to turn it up, but I give the reference, 5855 at paragraph 5e, where we made it very clear that if the appellant changed her stance and decided she would seek to justify and she would present affidavit evidence, we for our part would wish to cross-examine any deponent. I can say Mr. Crowe will have his own experience and the board will have its own experience. I cannot think of any case where proportionality has been relied on, justification has been relied on in a human rights or constitutional context without some evidence, without the respondent telling the court through evidence, not through the assertions of counsel, what its case is and why that is its case and how it has considered these matters. And these are all very important matters. My friend's answer, he says, well, look at Williamson. But in Williamson, there was evidence from the respondent, and there was an assessment at the court of first instance. There's no assessment here. There's no evidence. And his other point is, he says, well, he's concerned on behalf of the attorney that the issue may come back on another occasion. That would be most unfortunate. Well, with respect, we don't understand that point. These are the proceedings on the constitutional validity of Section 53. There's no question of that issue coming back. The board will decide it one way or the other. Even if there were later proceedings, even if there were, the Attorney General would then be well advised to argue her case properly in the local courts with evidence, with arguments, so that the local courts can give their assessment of justification issues. So I do respect, of course, respect what my Lord Reid has said, that the board is going to hear this de bene esse, but part of that assessment, I respectfully suggest, should be whether or not it is really appropriate to allow the Attorney General at this late stage to change her case. And for the reasons I've given, I say it is manifestly inappropriate with respect for the board to entertain the substance of the justification issue. I, of course, am now going to deal with what we say on that substantive issue. I want to deploy our full case. Just one other matter. My friend says, well, we, for our part, filed evidence in the local courts. Yes, we did, but we didn't file evidence responsive in the normal way to a justification argument because there wasn't any. And had there been proper deployment of the justification argument in the local courts, we would have responded, both with evidence and, as I've indicated, we would have sought to cross-examine. And I will come on, if I may, after the short adjournment to our points on the substance of the justification argument, if the board decides that it does want to entertain that. I will make my arguments, and I've also then got to deal, and I will deal with it briefly, as my friend did, with Section 12. Would that be a convenient moment, my lord? Your lordship's muted, I think, but I've got the substance of it.
Yes, we're all getting better at lip reading. Yes, we'll adjourn now and resume at 2 o'clock. Thank you.
Thank you very much, man. Thank you.